California tenants, did your landlord just send you an eviction notice by email? Before you panic, before you start packing, we need you to hear this. Under California law, an eviction notice delivered only by email is generally not legally valid. Your landlord just made a critical error, and we are going to show you exactly why. We are the Martinez Law Center, and today we are breaking down what happens when your landlord emails you an eviction notice and why the law is on your side. California law requires 3 specific methods of service, and email is not one of them. Under Code of Civil Procedure, Section 1162, an eviction notice must be served using one of only 3 methods. Personal service means handing the paper notice directly to you. Substituted service means giving it to another adult at your home or workplace and mailing a physical copy to you. Post and mail means taping the notice to your front door and mailing a second copy. Email does not appear anywhere on that list. If your landlord only sent an email, the eviction clock has not started ticking. Do not reply to that email before you understand this trap. Here is where many tenants make a costly mistake. If you respond to the email or acknowledge that you received it, some judges may rule that the improper service was cured because you demonstrated actual receipt. Do not reply to the email yet. Do not delete it either. Save it as evidence that your landlord attempted an invalid method of service. That email is now proof of their procedural failure, not proof that you were properly served. Even a valid notice does not mean you have to leave. We need every California tenant to understand this clearly. An eviction notice, even a properly served one, is not a court order. Your landlord cannot force you out, change your locks, or shut off your utilities when the deadline passes. To legally remove you, they must file an unlawful detainer lawsuit, win a judgment in court, and obtain a writ of possession for the sheriff to execute. Until a sheriff shows up at your door with that court order, you have every right to remain in your home. Check that notice for content errors that kill the entire case. Even if your landlord eventually serves you properly with a physical notice, the content must be perfect. For a 3-day notice to pay rent or quit, the amount must reflect only the exact rent owed. If your landlord included late fees, utility charges, or interest in that total, the entire notice is legally defective. $1 of unauthorized charges voids the whole document, and the landlord must start the process over from scratch. If you requested repairs recently, this could be retaliation. If you reported a habitability issue or called code enforcement before receiving this email, your landlord may be retaliating. Under Civil Code 1942.5, any eviction notice served within 180 days of a repair request is presumed retaliatory.
Call now, 714-442-9741. Thank you.